What's going on, y'all? Like, comment, subscribe if you haven't done so already. If you'd like to donate to the channel, the cash app's at the top right corner of the video. But let's get into it, man, because we got to talk about how UMG have filed a motion to dismiss Drake's amended complaint in this lawsuit. Yes, sir. It looks like UMG wasn't done cooking Drake. They brutally cooked Drake, doubled down on it with this second motion to dismiss. Now, they had filed a motion to dismiss the first time. Drake had to go back and amend the complaint. And now UMG is filing a motion to dismiss the amended complaint. Like, UMG is not messing around, bro. All the things that they said in this motion to dismiss lets you know that they are not playing. So this is the motion to dismiss the amended complaint. Let's go ahead and take a look and see what it is that UMG said in regards to this document right here. Now, initially, the first few pages of this motion to dismiss is essentially just a recap of the first motion to dismiss. They're basically just giving you the whole rundown of the beef, of the songs that were used, Not Like Us, Family Matters, Tailor Made Freestyle, Baca, His Case, the rap feud being a common thing. Rap beef is a common thing in hip hop. Drake being aware of the rap beef. He studies rap battles for a living. That's what he said. Euphoria, all the quotes, all the lyrics, all being quoted, everything right here. This is all just a recap, basically, from the first time they had sent the motion to dismiss. What really is the important part of all of this is the argument. The argument right here is what really matters, is really the meat and potatoes of this whole document. After they recap everything, the argument says that the legal standard, a complaint must plead enough facts to state a claim to relief that is plausible on its face. The court can credit only well-pleaded, non-conclusory factual allegations. In certain circumstances, the court may permissibly consider documents other than the complaint in ruling on a motion Rule 12b-6, including documents incorporated into the complaint by reference, and matters of which court may take judicial notice, including the fact that press coverage contains certain information. In particular, courts will take judicial notice of documents that Drake contends that the decision not to include the word PDF file, as used in the phrase certified PDF file, in Lamar's Super Bowl performance could only reflect that the language is defamatory, but this ignores any number of other explanations for the decision, such as threats by Drake of additional meritless litigation. Drake argues that because Kendrick chose not to use the phrase certified PDF file when he performed at the Super Bowl, even though it may have been used in the original song, Drake is using that and claiming that him not using the word would mean to Drake that the phrase is defamatory. And in other words, Lamar avoided saying it because he knew it would legally damage Drake's reputation. However, the counter argument from UMG is that they're saying that's a weak or overly speculative argument. Just because Lamar didn't say the phrase doesn't automatically prove it's defamatory. There could be many other reasons for omitting the phrase, such as the NFL being a family company. Millions of children are watching the NFL. It's on public television. There's more than enough reasons why Kendrick couldn't say that word on public television, not just because of Drake. It could even be the artist's choice not to say it. But nonetheless, if you've seen the halftime performance, you know that the phrase was censored, but Drake is trying to twist this and make an argument out of it as being defamatory. In hindsight, what this is really showing is that Drake was immediately planning on suing Kendrick Lamar and openly complained about the Super Bowl the minute that it aired. Just another example of you seeing that Drake was trying to sue from the very beginning. I don't think that Kendrick Lamar not uttering the phrase because Drake thinks it's defamatory is going to hold up in court at all. Drake is just trying to use the omission of a controversial lyric as evidence of defamation. But the court or the defense is saying that logic doesn't hold up. UMG saying it don't make any sense. There are many other reasons for an artist to censor themselves, alter content, whatever the case may be, especially on a public stage like the Super Bowl. Remember, a Rule 12b-6 is a provision of the Federal Rules in Civil Procedure that allows a defendant to ask the court to dismiss a lawsuit because the plaintiff hasn't stated a legal valid claim. And that's what they follow up with the second paragraph. Drake fails to state a claim for defamation. Drake, who had no concerns using UMG's platform to publish slurs about Lamar during the rap feud, now claims Not Like Us is defamatory. These allegations directly aimed at chilling legitimate artistic expression safeguarded by the First Amendment and are meritless. Drake fails to state a claim for defamation because Not Like Us conveys non-actionable opinion and rhetorical hyperbole. And because he does not adequately plead that UMG acted with actual malice, the alleged defamatory material is non-actionable opinion and hyperbole. To be defamatory, a publication must convey fact, not opinion or rhetorical hyperbole. Expression of opinion as opposed to assertion of fact are deemed privileged, and no matter how offensive, cannot be the subject of an action for defamation. And the footnote here is just letting you know that this whole situation, this whole lawsuit, and the angle that Drake is trying to take with it, he's trying to say that this lawsuit is not about the artist who created Not Like Us. UMG is challenging that and saying that Drake's repeated instances to the contrary merely betrays his recognition that his true battle was and is with Kendrick Lamar. It says here that Drake also claims that the lyrics of Not Like Us imply that they are based on additional facts not disclosed to the listener. This too fails as a matter of law. New York courts apply the objective reasonable person standard to assess whether a statement implies undisclosed facts, making it a mixed opinion. The court's essential task is to decide whether the word complained of, considered in the context of the entire communication and of the circumstances in which they were spoken or written, may be reasonably understood as implying the assertion of undisclosed facts justifying the opinion. Meaning, whether a statement constitutes a pure opinion or a mixed opinion is a question of the law for the court. That is, answered by considering, in the context of the entire communication and of the circumstances in which they were spoken or written, whether the average listener would reasonably understand the opinion as implying the assertion of undisclosed facts justifying the opinion. Drake points to two lyrics to support his argument that Not Like Us leaves an unmistakable impression that is based on undisclosed facts. Say, Drake, I hear you like 'em young. And the other lyric, the rabbit hole is deep, I can go further, I promise. Shout out the rabbit hole. These statements cannot be reasonably understood as conveying undisclosed facts. Drake's claim as to the first lyric is particularly stunning, as noted above. Drake himself goaded Lamar to talk about Drake liking him young, because right after that, Lamar then did so. Does not convey anything other than that Lamar accepted Drake's invitation. UMG is telling Drake right here, the only reason why he did that in the first place was because you told him to say it. You were egging him on. He hadn't even replied to you at this point, and you kept dropping songs and you kept talking to him. You kept provoking him. So he listened to you and accepted your invitation and decided to talk about how you like him young. In all events, the statements are too vague to support the weight that Drake gives them, as they have no precise meaning which is readily understood. More fundamentally, for the reason of tone and context already discussed, these rhetorical statements fail to imply any factual basis for the lyrics in Not Like Us. The court held that although two statements may cross the line into becoming potentially actionable mixed opinions, they do not imply undisclosed facts, where they could be reasonably understood as part of a tasteless effort to lampoon because they were made in circumstances where an audience may anticipate the use of epithets, fiery rhetoric, and hyperbole. They doubled down by saying that Drake's argument also fails because the statement in Not Like Us relates to other controversies. Indeed, to the extent of the quotations rabbit hole has any understood meaning. It does not imply undisclosed facts, but rather pursuing a known piece of information. Alice followed the rabbit down the hole to Wonderland. That is crazy. And in that sense implies Lamar is referring to a well-known rumor regarding Drake's relationship with Mike. And this is where I think they absolutely cooked Drake at this point, bro. I think they're really doubling down here. I mean, for the love of God, bro, they're referencing the rabbit hole and they're saying that Kendrick is only saying these things about you because they're well-known rumors regarding Drake's relationship with youngins. Now, this is the part where I was talking about when UMG had made that response not too long ago. When UMG was talking about how a discovery could go both ways and be careful what you wish for, I think this rabbit hole angle that they're going with in this lawsuit could get a lot more messier and it could go a lot more deeper, I promise. Although some of the statements are based on undisclosed, unfavorable facts known to the writer and disgruntled tone, anonymous posting and predominant use of statements that cannot be definitively proven true or false supports the findings that the challenge statements are only susceptible of non-defamatory meaning grounded in opinion. Essentially, what they're saying is that Kendrick is just making the song based off of rumors that are well known to everybody, which is crazy to say because UMG, the people that have been taking care of Drake for years, their own artists, they're the ones that are saying that it's a well-known rumor regarding Drake's relationship with youngins. Drake also alleges the statements in Lamar's Euphoria, including "Don't tell no lie about me and I won't tell truths about you." And I know some ish that may gonna want to look like a saint imply that Not Like Us is based on undisclosed facts. For the same reasons discussed above, this argument fails both in light of the rhetorical hyperbole of the artist rap battle and because there is no connection drawn between these lyrics and the statements in Not Like Us. UMG wasn't done cooking Drake there, bro. They decided to keep going. They wanted to go further, and they really wanted to let Drake have it. Because the next paragraph is insane. It says, facts and criticism concerning Drake's relationship with mine predate Not Like Us and have been widely reported. Widely reported is insane. The criticism of Drake's relationship and all that being widely reported is diabolical, bro. Like UMG going at Drake this way. Remember, these are the guys that have been taking care of Drake for a really long time. This is their artist. indicating Drake for years of rumors of speculation around his misbehavior around youngins, and that Millie Bobby Brown is one of the things that most people are aware of when it comes to Drake and the rumors around him. In the Heart Part 6, Drake also affirmed that he understood Lamar's statement in Not Like Us to refer to Millie Bobby Brown's controversy, stating that this Epstein angle was the ish that I expected, and I only effing with Whitney's, not Millie Bobby Brown's. I never looked twice at no teenager. Clearly, Drake himself understands that Lamar's lyrics refer to well-known issues that have been widely reported. Drake's arguments concerning undisclosed facts carry no weight at all. And the footnote is interesting because it says right here, we all know the stories of him going to girls' basketball games. There are some things that we've seen and heard over the years. It's kind of wild that this has been in the atmosphere for some time, but no one has previously called out Drake in this way. When Millie Bobby Brown was 13, she met Drake at a concert. He was 30 or 31 at the time. She said they would text a lot in interviews and they maintained their friendship where he would give her advice about boys and stuff like that. This was spoken about in interviews. Allegations of Drake having inappropriate relationships, Drake having these suspicious relationships with youngins is a topic Drake has had to debunk in the past. Not Like Us reflects these rumors surrounding Drake's personal life. Now, this becomes a very big conflict because your label is essentially saying that these rumors about our artist that is suing us, they have been going around for years. Not Like Us is a reflection of those rumors that have surrounded Drake's personal life before the beef had even started. And I think this is just one step going further into where UMG could take it if Drake continues to play this game. I think that UMG not only doubling down in this way, but if it gets to that point, I really think that they're really gonna start talking, bruh, about any type of escapade that they're aware of, that we're not aware of about Drake. It says here that Drake cannot allege that UMG acted with actual malice. Drake claims should also be dismissed for failure to plead actual malice. A public figure can prevail on defamation claim only where clear and convincing evidence proves that a defamatory statement was published with actual malice. That is, with deliberate or reckless falsification. The element of actual malice focuses primarily on what a defendant knew or believed at the time a purportedly false statement was made. Because UMG is a corporation, Drake must also plead specific allegations that individuals at UMG acted with actual malice. At the time that they participated in the publication of the statement in question, Drake does not and cannot plead that any specific person acted with actual malice. His defamation claims fail for this reason as well. Essentially, what they're saying is that because UMG is a corporation and not a person, Drake can't say that UMG defamed me. He must go further and specifically identify a person at UMG who could have done that. The argument here is that Drake hasn't and likely can't point to an individual at UMG who acted with actual malice in publishing statements he's complaining about. Because of that, his defamation claim will fail, especially against a corporate defendant like UMG. They have millions and millions and millions of dollars. They're the ones that were signing Drake's checks. So if you think that they can't go against Drake forever, you're completely wrong about this, bro. But remember, Drake has to prove that the statement was not just false, but that the speaker knew it was false or had reckless disregard for the truth. And it leaves the question again, why are you suing UMG and not Kendrick Lamar? Like people say, he wants to mask this lawsuit like if he's being a hero going against the machine. Realistically, he's just salty about the loss, but doesn't want to make it about Kendrick Lamar and doesn't want to make the lawsuit about him losing against Kendrick. He wants to make it about UMG and him trying to change the story. But if that's the case, he would have named somebody already. It says here, courts also recognize that the malice inquiry must focus on what the publisher intended to convey. Whether the speaker intends a statement as outrageous parodies or caricatures, there may be no consciousness that the speaker is publishing something false because the speaker does not think he is publishing a statement of fact and therefore lacks subjective knowledge or recklessness as to the falsification of statement of fact required to show actual malice. So to hear UMG released a rap diss track conveying rhetoric and insults, Drake has not alleged that anyone at UMG intended to convey anything other than what this was, an incendiary diss track. Like I said, bro, Drake's issues are with Kendrick Lamar. It's not with UMG. Drake fails to state a claim for a second-degree harassment. Drake asserts a claim for harassment in the second degree under NY Penal Law 240-26-3, claiming that Lamar issued a call to target, including through violence, and that Not Like Us amounts to incitement. This claim fails for multiple reasons. Means that a private right of action is inconsistent with the legislative scheme. Courts, therefore, routinely hold that 240-26 does not create a private right of action. This passage is basically arguing that the New York Penal Law 240-26, which is also known as second-degree harassment, does not give private individuals the right to sue someone under it because it's a criminal statute and not a civil one. UMG is saying that Drake is trying to use this criminal law as a basis for a civil lawsuit, which the court says is not allowed. So there's a chance that this is going to be dismissed. So there's a chance that even if this keeps going on, there's a chance that this second-degree harassment situation could be dismissed because of that. You can't sue someone civilly under this law for harassment. You need to base your claim on a civil statute and not a criminal one. Finally, Drake fails to allege that UMG acted with no legitimate purpose in publishing and promoting Not Like Us. The phrase no legitimate purpose means the absence of reason or justification to engage someone other than to hound, frighten, or threaten. Here, Drake expressly alleges that UMG motives with respect to Not Like Us were financial. Here, Drake expressly alleges that UMG's motives with respect to Not Like Us were financial. Drake fails to state a claim under NYG BL 349. Immediately after the release of Not Like Us, Drake started making baseless accusations that Lamar was using superstitious means, such as fake streams, to make the song appear more popular than it is. Now Drake has attempted to shoehorn his grievance into a NYGBL 349 claim against UMG. Drake claims that UMG made materially false and misleading representation about the recording's popularity to consumers without disclosing that it was covertly financially incentivizing third parties to play, stream, and promote the recording, including paying others to use bots to stream the recording. Drake cannot satisfy the elements of the GBL 349 claim. First, Drake fails to plausibly allege a convert scheme. All of his allegations are on information and belief. Bot allegations on information and belief, and that's going off of the academic stream, all these other things that Drake had gotten from the internet, Drake had gotten online. Drake has also received information that UMG engaged in a classic pay-for-play scheme by paying to increase the airplay for the recording on the radio, but such allegations must be accompanied by a statement of the facts upon which the belief is founded and cannot rest on pure conjecture and speculation. This is true especially with regard to consumer fraud claims such as those under GBL. After withdrawing his prior false allegations, which were the ones that he removed because those were the ones he used the academics reference that just didn't add up in court, was frivolous, and they threw it out. Drake had to amend his lawsuit and take it out. So after withdrawing his prior false allegation that UMG was accused on the podcast of paying to use bots to stream Not Like Us, Drake is now reduced to citing different podcast hosts who claim that Kendrick used bots so that a Drake record would have more dislikes than likes. This is him referencing Joe Budden's podcast. And let me remind you that Joe Budden has already came out and said that he was lying. And he has a disclaimer in his videos that say that everything that he says isn't to be taken serious or to be used to indict anybody. He also relies on now deleted anonymous X comments accusing Lamar of buying promo to clown Drake's lawsuit, not to promote Not Like Us, as well as another post claiming that UMG and Lamar used a bot streamer. Courts reject such online comment-based pleading because online comments are utterly failed to make plausible the underlying factual claims. This is them cooking Drake because they're like, I don't know why Drake keeps using Twitter and comments from the internet to try to prove a point. Thus, these comments cannot save Drake's information and belief allegations. Drake's remaining allegations are even more speculative, such as 2 X posts from July showing Not Like Us being recommended to Spotify users who search for rap artists. Drake also fails to plausibly allege that UMG had actual knowledge of any conduct or accusations concerning Lamar. Moreover, Drake cannot allege that any representation about the recording's popularity to consumers were actually deceptive or misleading in a material way. And I think that it's hilarious how they get at Drake about using comments in the comment section and the way that Drake uses references. They even got a few of these Twitter accounts to let you show that these are the usernames that Drake is getting of the people that Drake is referencing in this lawsuit, just to show you how ridiculous it is. Drake using these random burner accounts to prove his point on the lawsuit. The comments cited in Drake's complaint make this point. They are rife with grammatical errors, slang and emojis, and authored by sources such as Wrestling Warrior 15, Meow Meow 1234 Meow, and I'm Chicken Little on X. This is crazy, bro. These are the references that Drake is coming with. This is insane. And I see why UMG is pointing this out. It is so ridiculous to reference these accounts on a lawsuit like this. And when I went over the amended complaint the first time, I was clicking all of these links and they were just taking me to random accounts on Twitter, bro. It was almost laughable. It was laughable. It's so ridiculous how many hyperlinks that they put from Twitter in the amended lawsuit. They took out a lot of information, they took out a lot of their arguments and filled it with regurgitated bullshit that you find on Twitter by people like Meow Meow 1234, I'm Chicken Little, and Wrestling Warrior 15. I think that's the point that UMG is trying to make with all of this. Drake does not and cannot allege that Not Like Us would have not been an immense success had it not been for the alleged financial incentives at issue. That is, there are no alleged false or deceptive statements, even assuming that these payments occurred, nor does Drake allege that knowledge of these alleged covert payments would be material to consumers. After all, there's no obligation under GBL 349 to provide whatever information a consumer might like to know. Second, Drake's injury theory is that 1, each time the recording was artificially streamed, Drake's songs received a disproportionate share from the pool of royalties collected based on the streaming data. And 2, every time the recording was played on the radio, Drake lost the opportunity for one of his songs to be played. But such far-fetched claims are not cognizable. The proposition that a Drake song would necessarily have been played instead of Not Like Us is pure speculation. Nor does Drake allege how either claim injury was caused by a failure to disclose the alleged financial incentives. That is, how they were a result of the deception. And in any event, Drake's GBL 349 claim fails because he only alleges injuries that are indirect on harm to third parties. So that was the lawsuit, 33 pages. It was a big read. It was a really big read. I appreciate everybody who stuck around to the very end. I think they doubled down on a lot of things that they said the first time they had made the argument, and now they're doubling down and saying all of these things, talking about the references, talking about Drake, inviting Kendrick to say those things. The rabbit hole angle was crazy. I really think that them talking about the rabbit hole the way that they did, they're leaving it for open discussion. This wasn't created by Kendrick Lamar. There were rumors that were already circulating. If anything, all Kendrick did was use those rumors in a battle, and those rumors just happened to go viral. They reached the surface. And the thing is that people before this battle had always said, Drake has always been questionable in regards to stuff like that. But it's the fact that it's coming from his label. The company that has been with Drake for 15 years has had a business relationship with UMG for many, many years. So when it's them saying that the rabbit hole has always been there, it makes you think, what else do they know? And what else can they bring to the surface? Because it's like they said in that warning, be careful what you wish for, because you just might get it. I don't think the discovery has happened yet. But it's like UMG said, the discovery goes both ways. We know what Drake is going to ask for, the contracts and all of that. But really, it's what UMG is going to ask from Drake. What are they going to ask Drake for? And in my opinion, I think UMG already knows what to ask Drake about when it comes to the discovery. I think UMG doubled down and cooked Drake again, bro. Barbecue chicken. Burnt to a crisp, bro. I'm just being honest, bro. But y'all tell me how you feel about this, man. Y'all get back to me in the comments and let me know. Like, comment, subscribe, and I'll see y'all in the next video, man. Peace. Keep it a legend.